Hey everybody, this is going to be a super quick overview of the 2025 residential purchase contract in Oklahoma. We will do a deep dive page by page on different videos, but I just wanted to do like a quick overview. And then if you need a deeper dive into like a specific page, rather than having to sit through this whole thing, you'll be able to go just to that page and get the deep dive on the information you're looking for. So we're going to start at the top of the first page. You're going to see the address of the property that's being purchased there. This next section has to do with any attachments that are part of the contract. So do not put any X's there unless you have the corresponding document to attach to the contract to go with it. Then we're going to see the seller's names and the buyer's names. The seller's names you're going to find in county records or through the county assessor, or you can also look at the disclosures, but don't rely 100% on the disclosures because sometimes a trustee or someone will sign the disclosures on behalf of the seller and not the actual owner of record, which is who we need in the contract. And then the buyer's names, you're going to find those off of the pre-approval letter. So then we're going to go down to the contract is fully executed by signature. So that's just a reminder that earnest money is not something that's executory with the contract, but it is a voidable condition of the contract. So remember, we can't cancel contracts due to lack of earnest money. You're going to have the county filled out here, and then the legal description. You can copy it out of county records. I am not a fan of that. So if you ever receive an offer from me, it's going to have the legal description all spelled out. Lot X, block Y, whatever the addition is to the city that it's in. Then it's also going to be known as the mailing address. This is very important to lenders. Nobody else cares because everybody else goes off of the legal description, but lenders are going to be very specific about wanting the full mailing address in there, including either street, lane, avenue, parkway, whatever it is. So the way their contracts are written in Oklahoma, it's based off of a cash transaction unless there's a financial addendum attached up at the top. So that's why we don't put cash as an addendum up at the top of the page. Then we have the purchase price, the earnest money. The earnest money is going to be delivered to the title company of the buyer's choice where they're wanting the property to be closed. Then we're going to have the projected closing date at the contract, and part of the closing process includes receipt of funds. So we used to put that closing occurred at funding. That's part of the contract, so we don't need to add that in anymore. But this one's the seller is going to complete the process and buyer prior to December 31st of 2025. Then we're going to see the buyer's initials and seller's initials on the bottom of every page. Top of every page, we have the address that's being purchased. Then the top of the second page breaks down of the closing costs, who pays for what. So what fees are the buyer's responsibility and what fees are the seller's responsibility. Then we get into the accessories and equipment that come with the house. And this is basically everything that's attached to the house stays with the house. If it's not attached, it may or may not stay. There is some questions about Ring doorbells, so I would just add it in until somebody says otherwise. Same thing with security systems. Sometimes they're actually screwed in, so they are physically attached. Sometimes they're just sitting there. So if that's something that's important to the buyer, make sure that you add it in. Exclusions, a car behind a detached garage should be personal property and should go away, but if it looks like it's been there for a while, I would go ahead and, or if there's anything else for your buyers that they really want to make sure is gone prior to closing, just go ahead and write it in, and that way there's no surprises when you get down to it. So time periods in the contract, you can play the guessing game on what this is, or you can just fill in a date. And you know that if you've taken my contract classes before, I'm a big fan of putting in dates, and then that way there's no room for any misinterpretation of what the intent was. So time reference date, that is what every part of the contract going forward is going to refer back to. It's not going to refer back to signature date, the date the offer was made, anything like that. It's going to be the time reference date. And the reason that we do inspections is because no representations made by the seller regarding condition of the property are expressed or implied. So the residential property condition disclosure is one of the things that the buyers need to inspect to make sure that that information is accurate. It's only as goes as far as the seller's knowledge on the day that they filled it out. So for the time period on inspections, the contract defaults to 10 days. You can put 15 days if you think it's going to take a little longer to get the inspector in there. You can put 5 days if you have an inspector in your back pocket that'll get right out and get it done. This is something that's negotiable. And a shorter inspection time frame sometimes will make your offer more appealing to the seller. And again, we see buyer and seller's initials on the bottom of the page. These are all of the things that the buyer can inspect. There's 12 things listed out. 13 is left blank if there's something else specific that the buyer wants to investigate. I've never had a buyer come up with that, so I don't know what that magic 13 number is. But if there is something, they have the right to inspect for it. Treatment of termites is actually pulled out of the repair negotiations, but once a seller knows that they've got termites, they have to treat it more than likely to sell the property anyway, so it's usually not that big of a deal. Paragraph 2 here is the one that I get the most questions on, and it's the one that causes the most confusion. So we're just going to take it step by step, and this is the one deep dive I'm going to take in this part of the video. But after the inspections are done, the buyer shall deliver to the seller a copy of all written reports obtained by the buyer. This does not mean the appraisal, however, because the appraisal is something that's obtained by the lender. And the only time that we turn over the appraisal is if the appraisal is short or if there's requirements, and then we just turn over the pages that apply to that. We don't turn over the entire appraisal. But any other written reports that the buyer receives have to be turned over to the seller. It's non-negotiable. It's in the contract. It says shall. That's what's going to happen. So that's what happens first when the inspections are over. Second is the buyer shall select one of the following options. So we've turned over the inspection reports. Option 1 is they, in their sole opinion, can cancel the contract and receive their earnest money back. And this is where it's really important that us as realtors don't try to be helpful. And this is one of those places where we just, silence is key. We have to zip it. It is in the sole opinion of the buyer. It's not, well, what if the seller replaces the roof? Well, it doesn't matter. All we say is, in the sole opinion of the buyer, this house is not going to work for them. And here's our cancellation. We need the earnest money back. That's it. The other option that the buyer has after they've turned over the written reports is they can submit a TRR to the seller requesting whatever items that came up in inspections that they want to have addressed and want to have fixed. If they turn in the TRR form to the seller, they are waiving their right to cancel the contract. So that's why that's an either or. They can choose one or the other. They can cancel the contract or they can send the TRR. Once they send the TRR, they're on the hook for the house if the seller agrees to repair the things that they've asked for. Now, if the seller counters back and says, I will fix 1, 2, 3, and 7, but I'm not going to fix 4, 5, and 6, then the buyer can back out of the contract again at that point. But once they submit the TRR, they're committing to move forward with the house as long as the seller makes the repairs that they've requested. That is also the last time that the seller has the opportunity to cancel the contract. So if they send in the TRR, the seller can say, no, here's your earnest money, we're done. So this part of the contract is really, really kind of important, but it's also one where people really get hung up. So if you have questions, talk to your area leader, reach out to me, reach out to Katie. One of us will help get you through this part, but I just want to take a few more minutes to go over that one. So after the TRR is submitted, then the buyer's right to cancel the contract is expired. So if they haven't done the inspections within the correct amount of time, if they didn't do the TRR, if they didn't cancel the contract within the time reference period, then they're moving forward with the contract. Also, if they didn't find out if they couldn't get the loan based on hazard insurance, they're still moving forward. And if there was any issues with the square footage of the dwelling, not limited to appraisal because that's separate, then the buyer is still obligated to close on the transaction. So then we go to inspection of treatments, repairs, and replacements. The buyer does have a right to do a final walkthrough and make sure that all of the repairs that they've requested have been complete and that the house is as they were requesting it to be delivered to them. So risk of loss, this is just up until time of closing. If there's any loss on the property, a fire, tornado, things like that we see in Oklahoma, the loss is going to go toward the seller. Just because the buyer has a contractual interest in the property is still the possession of the seller. And so any insurance benefits or things like that would go toward the seller. Once the buyer has accepted the property, it's the buyer's property at that point. There's no warranties expressed or implied by the sellers, the brokers, licensees, anybody at that point. So once we're closed, we're done. Now we all know in reality, if they call and they need an electrician or a plumber, we'll send them 3 names and let them choose. But typically once the property is closed, that's it. Title evidence, the seller will pay to have the abstract brought up or will give the title company a copy of their insurance policy, and the title company can work from a previous insurance policy forward and do the abstract search that way. And then the buyer, at the buyer's expense, is going to either request title insurance at the, so they're going to get a title policy of their own, or they can request an attorney's title opinion. In the metro areas, we almost never see a title opinion. In some of the rural areas, you will see that. The thing to remember is the attorney's title opinion is only as good as the attorney and only as good as the day that they look. So the going with title insurance, the opinion is backed by an insurance policy and has a little bit better coverage and better protection for buyers. And usually what I tell them is the bank is going to make you buy title insurance for them because it's important to protect the bank's interest. So why wouldn't you buy title insurance for yourself to protect your own interest as well? Next is the land survey or mortgage inspection report. This is another area where it varies greatly on how we normally do business, depending on what part of the state you're in. So when I started in a rural area, we didn't do mortgage inspection reports. We didn't do surveys if it was lot and block property in town. So most often it was the buyer elected not to receive any reports unless required by title or by law. The urban areas, most of the title companies are going to require the mortgage inspection report to issue title insurance. So more than likely, they're going to have to do it. There was some confusion about whether this was a title question, so a seller's expense, or if it was an inspection question, which is a buyer's expense. So they, just to make it clear, have added into the contract that whoever's paying for it, you can select whoever's going to pay, cover that expense. So one of the new things that they've added to the contract. At the bottom of page 4, it says that the buyer shall have 10 days after receipt to examine the title evidence. I cannot emphasize enough how important it is to get the title evidence delivered to your buyer as soon as you receive it from the title company. Some of the title companies will go ahead and forward it to them also, but just to make sure we have it documented that it's been given to them, and when that 10-day time frame starts, we need to make sure that we've got that in our records as well, that they have received it. And again, buyer's initials and seller's initials at the bottom of the page. Then at the top of the page, the seller has X number of days to correct any issues with title. The contract defaults to 30 days. Normally, I'm a big fan of putting 5 or 7 in there. Usually with clouds on title, it's either something that can be resolved very quickly or it's going to take a lot of time. So I usually try to keep that time frame for that pretty tight. Taxes, assessments, and prorations. This is just breaking down how taxes, HOA, things like that are all going to be split up in the contract. And then we've got the residential service agreement. And this is if the buyer is going to request a residential service agreement, they can. If the seller has one that's transferring, that needs to be noted here. And then it also breaks down who's going to pay for it if the buyer is requesting it. The buyer can pay for it 100% on their own. They can split it with the seller. All of that's negotiable. Then we have additional provisions. And the only thing I'm going to caution you on here is we are not attorneys. So the Real Estate Commission has given us 2, maybe 3 pages now of standard clauses that are approved by them that we can use for or in the additional provisions part of the contract. If it's something that is not covered on those standard clauses, please reach out to your area leader or to the broker and make sure you get assistance on those provisions, because we aren't attorneys and we shouldn't be writing contracts. Mediation, that's just by signing the contract. Everybody agrees to go to mediation before we go to court. Again, buyers and sellers initials, and the property identifier is going to be across the top. The contract is covered by the laws of the state of Oklahoma. So if it does end up in a legal dispute, the dispute's going to be settled here and in the county over which the property is located. If there is a breach and failure to close, the contract breaks down what happens if the seller breaches the contract, also what happens when the buyer breaches the contract, any incurred expenses, who's responsible for those. Remember back a couple of pages, I said this is where it tells you who's responsible for what costs. This is, says that they have to be paid by the parties who are responsible for those costs. Those costs cannot be paid out of the earnest money. And the reason for that is if the buyer's in breach and the seller agrees to accept the earnest money as compensation and not to move forward with specific performance against the buyer, they can't pay for inspections and things like that out of the earnest money because it's going to be the seller's earnest money due to the buyer's breach. So it's just best to keep those things in 2 separate buckets and not confuse the two. So then we go over delivery of a counter or counter offer, definition of non-foreign seller, that the buyer agrees to, or at time of closing, they're going to be a U.S. citizen. They're going to be in process of becoming a bona fide resident of the state of Oklahoma. And then there's a termination date on the offer. The termination date is actually very important because if we have a offer that's sent out without a termination date, the seller can, at some point in the future, sign the offer, and since it wasn't terminated, the offer can become a binding contract. So it's very important that you terminate the offer or send a written notice to the listing agent that you're rescinding the offer and it's no longer on the table, just to protect your buyer from buying 2 houses. And then we have to hope that they actually qualify for both houses that they've got offers in on. So one last time, property identifiers at the top of the page. And then we have the buyers and sellers, names printed, the date that they signed, and their signatures. There's places for 3 buyers and 3 sellers. If you need more than that, you can do an addendum to the contract and add as many buyers and sellers as you need to. I had one once where the sellers were deceased and the property was held in a trust, and the trust was the beneficiaries of the trust were all 7 children and their spouses. So that one, we had quite a lengthy addendum, and the deed ended up having to have everybody's signature on it. And fortunately or unfortunately, one of the children was deceased. So we didn't actually have 14 people have to sign the deed over, but there was a lot of people in the room when it came to time to closing. So that's on buyers and sellers, name, signatures, date signed. Then on the realtor information, make sure you've got your name, your license number, the company name, company license number, address, phone numbers, all of the things. This just makes it easier for title because they've got all the contact information there. It also makes us look more professional that we're filling all of those things out. Also, the buyers and sellers have a right to know how to get a hold of us if they need to. So that's all of that information goes there. And then one last time at the bottom of the page, we've got the buyer's initials and the seller's initials. So a couple of other just quick things to note. If the buyer is unrepresented, for the buyer's broker or buyer associate, it's none. The buyer's representing themselves. And then it's going to be up to the buyer, since they're self-represented, to get in contact with title and make sure that title and lenders have everything that they need. Similarly, if the seller is unrepresented, you just put that it's a for sale by owner, and then it'll be up to the seller to work through keeping in contact with the title company. So that's it. That is a rushed view of the purchase contract. If you have any questions, make sure and reach out to your area leader or the broker, and I will be doing a deeper dive on this page by page and get it up shortly.